There we go. Thank you, Claudia. So, by the way, if you have any questions during the session, you can ask them in the chat, or you can raise your hand. I think I can see you. Otherwise, I will have a space at the end for any questions that you may have regarding the subject of today's session. And so, as I was mentioning, the approach to this class will be a little more conceptual. I will focus on scrutinizing, in a way, what constitutes international law and each of its very ample characteristics. And the subjects that I will be addressing, you can see in the screen. I will be first addressing the status of international law as a legal system between states, its status as an independent system, its status as a horizontal system, its status as a consent-based system, and finally, a subject that is very interesting and in its way very challenging, its status as a fragmented system, as a system that suffers from fragmentation. And so on that note, I will proceed to the first aspect of this explanation. So the classic concept of international law that you will find in books, especially older books, is that international law is a body of law. Sometimes people say a branch of law, which I will argue is not correct, and I will say why subsequently in a later slide. But it is a body of law that governs the relations between states. This is the classic concept of international law that remained true for a long time, but has over the last few decades changed substantially. And much of the reason for this change is the recognition that the international legal system is not supposed to only govern the relations between states. And we see over the course of the last few decades, especially after the advent of the United Nations, that there has been a rapid emergence of new subjects of international law that are legally relevant and that have changed the landscape of the law as we know it. And so to give two examples of this, I will address first the problem that arises from the existence of international or intergovernmental organizations, and also the status of individuals in the international system, because these two aspects of the history of international law are very illustrative when addressing whether or not the law has actually changed when it comes to the subjects of law. And alongside these subjects, you will find many others. You will find, for example, what many authors call sui generis territorial entities or sui generis subjects. And I will not be delving very deeply into that, but the remarks made in respect of international organizations and individuals will generally be also useful to understand the emergence of other subjects. And so to start with the international organization aspect of this question, perhaps the most important development in this respect is the International Court of Justice advisory opinion regarding reparations for injuries suffered in the service of the United Nations, or simply called the Reparation Advisory Opinion. As many of you may know, this is an advisory opinion that was born out of discussions within the Sixth Committee of the United Nations General Assembly regarding the capacity of the United Nations to bring international claims when a person that is acting as its agent has suffered injury. This question could not be resolved in the political aspect within the Sixth Committee of the UNGA, and so it was decided to refer this question to the ICJ. Within the International Court of Justice advisory opinion in this respect, and I encourage every one of you to take a look at it. It's rather short compared to newer advisory opinions and judgments of the court. The ICJ's advisory opinion in this respect has a very significant finding near the end, where it is faced with the question whether the personality of the United Nations as an international organization has to be recognized by states that are not members of the organization. In other words, whether the UN has a legal personality that is opposable to non-members and therefore objective. And the court made a very, very significant finding, where it said that the founders of the United Nations, which at that time were around 50 and represented the majority of the international community, quote, had the power to bring into being an international organization named the United Nations. And therefore, this new organization, which had its own rights and obligations, needed to have objective legal personality. That is to say, legal personality that is opposable to non-members. And we see that this same recognition that is made by the ICJ in respect of the United Nations has made ripples in the international system. An example of this is what you see in the second bullet within the IO question, which is the decision by the International Criminal Court. This is a recent decision. I believe it was handed down in 2019. It concerned the jurisdiction of the court over crimes that were committed in the territory of Myanmar, but which were completed in the territory of Bangladesh. And as you may know, Myanmar is not a member of the International Criminal Court. So the question was whether the personality of the ICC could be opposed to a state that is not a party to the Rome Statute. And the court, mimicking in a way the language used by the ICJ in its 1950 advisory opinion, said that the ICC has an objective legal personality that was brought into being by a significant portion of the international community, and therefore its personality was opposable to third states that were otherwise not bound by the Rome Statute. And so we see that in these subsequent recognitions, and we also see it in the work of the International Law Commission, that international organizations have been recognized as being capable of acquiring rights under international law, and in fact, exercising those rights in the international sphere. And we also see in a further development in 2011, as a result of extensive work by the International Law Commission, the adoption, or well, not the official adoption yet, they're still in draft form, but the consideration of the draft articles on the responsibility of international organizations, or as they are also called, the DARIO. These articles recognize in the same way as the articles of state responsibility do for states. These articles recognize that international organizations are also subjects of obligation. And when they are in breach of those obligations, they are liable under international law, and they are subject to the content of responsibility as recognized in customary international law. We also see another important development is the adoption in 1986 of the Vienna Convention on the Law of Treaties between states and international organizations, and between international organizations. This is the sister treaty to the Vienna Convention on the Law of Treaties that you may be familiar with. This convention is not in force yet, but its purpose is to adapt the rules of conventional and customary international law regarding treaties to treaties conducted and concluded with international organizations. And so we see that the international system has received this recognition of IOs as subjects of the law. And so nowadays we can consider that this idea that international law only exists between states and in their relations is no longer fully correct. Another example, and this is a form of evolution that we can gauge through the lens of diplomatic protection, is the recognition of the rights of individuals. And so this has been a development that is very much marked by the advent of the United Nations, and the creation of a self-standing body of human rights law, along with its related bodies like humanitarian law and international criminal law. The international legal system is now held to recognize individuals as, in a way, limited subjects of law. This evolution can be seen comparing a decision by the Permanent Court of International Justice, which, as you may know, is the predecessor of the ICJ, in its famous Mavromatis concessions case in 1924. You can see the quote on the screen. And in particular, what is significant about this case, this finding, by the way, has become classical. It is mentioned a lot. Is that when a state exercises diplomatic protection over an individual, that is to say that when the state takes up the claim of an individual, of one of its subjects or nationals, it is not acting on behalf of the rights of that individual. It is acting in the exercise of its own rights, or in the words of the Permanent Court, its right to ensure in the person of its subjects respect for the rules of international law. And so we see that the rights that are claimed by the state in the conception of the Permanent Court of International Justice are not the rights of the individual at all. They are rights of the state. And this is therefore a state-centric notion of diplomatic protection. And we see that this notion has changed. One example of this is the 2007 judgment. This is a judgment on preliminary objections by the ICJ in the Amadou Sadio Diallo case, where at paragraph 39, the court states, as you can see in the screen, that international law as it stands today, that is to say in 2007, because of the development in recent decades of rights, or particularly the body of international human rights law, it is recognized that international law accords rights to individuals. And therefore, the court not only recognizes this, but also says that this conferral of rights under international law has substantially modified the scope in terms of substance of the concept of diplomatic protection, in the sense that now diplomatic protection is not simply the exercise by the state of its own rights in respect of an individual, which is its subject or national, but it is truthfully the exercise of protection by a state in respect of rights that accrue to the individual itself, and that the state only takes up because of the link of nationality. And the court mentions especially that one of the causes of the widening of this concept is the recognition of internationally guaranteed human rights. And so as a result of this is rather the evidence of a development in international law, where it is now recognized that the individual holds rights in itself. This is precisely the body of human rights law that represents this evolution. And we see that these rights, which are now recognized under international law, have been developed extensively. We have, from a theoretical perspective, can be classified rights of different generations, and these all accrue to the individual or to peoples, as may be the case for rights like the right to self-determination. And another significant issue to mention is that international law also recognizes the duties of individuals. And perhaps the best evidence of this can be found in the body of international criminal law. Nowadays, as it is understood by international tribunals, international criminal law establishes prohibitions that have a jus cogens level of recognition. And these obligations not only generate the responsibility of the state in case of breach, but they also generate individual criminal responsibility. And this could only be possible if the international system granted or imposed on individuals and corporations their own responsibility and their own obligations. And so we see that the international system has evolved to also recognize that individuals themselves have international obligations. The reason why individuals are still recognized as limited subjects of law is because they do not have lawmaking powers, as states do in the international sphere, and as international organizations also may have in specific instances. And so this idea that the international legal system is a legal system between states has all but been abandoned in the practice of states and international organizations. So this is the first aspect that needs to be understood, that the international legal system is no longer state-centric. Of course, the state remains the principal subject of law, but it is no longer the only one, or even the most important. As for the second aspect of this explanation, we need to address what it means that international law is a legal system. This is a subject that may be taught in your universities when addressing the concept of the reception of international law within domestic systems, or the relationship between international law and municipal or internal law. That is to say, the law created by states in the exercise of their sovereignty to apply usually within their own territory. And so one of the key questions that is posed in this respect is whether international law and internal law have a relation of supremacy on the one hand, or a relationship of independence. And this is a very significant question. This is a very significant question because if international law has supremacy over internal law, this is in a way to recognize that they both occupy the same legal space, except that international law has in a way, a higher status within that space. On the other hand, to recognize the independence of international law would be to say that internal law is something completely different. And so what you may have found when studying international law is that Article 27 of the Vienna Convention on the Law of Treaties says that a party may not invoke the provisions of its own internal law as a justification for the failure to perform a treaty. And so internal law is not a justification for the non-observance of international obligations. But this provision, which by the way represents customary international law, which I will explain later, this provision doesn't answer the question of whether international law is superior or independent. And so I will refer to some case law that may be useful in answering this question, as well as some academic writing in this respect, particularly emanating from the International Law Commission. The first example is the Electronica Sicula case before the ICJ, also called the ELSI case. This was a case the judgment was handed down in 1989. And we can see in paragraph 73 of this case that the court recognizes very, very clearly that there is some degree of independence between international law and municipal law. The court says, and I quote, "What is a breach of a treaty may be lawful in the municipal law, and what is unlawful in the municipal law may be wholly innocent of violation of a treaty provision." And so the court in this passage is recognizing that the question of international responsibility for the breach of an international obligation means or is regulated by international law itself, and that municipal law does not enter into this equation. We also find the same recognition, and in fact, this is based on the ICJ's judgment in ELSI. The ILC Articles on State Responsibility, Article 3, clearly state, and I quote, that the characterization of an act of a state as internationally wrongful, that is to say, in violation of an international obligation, is governed by international law. And in that respect, quote, "it is not affected by the characterization of the same act as lawful under internal law." And so this adds some elements that are relevant to the theory that international law and domestic law are independent systems. And perhaps the best example for proving the independence of international law is the judgment of the Permanent Court of International Justice in 1926 in the case concerning German interests in the Upper Polish Silesia. At page 19 of this judgment, the Permanent Court says that from the perspective of international law, municipal laws are merely facts. That is to say, they are acts of a state. They may themselves be wrongful if they contradict an international obligation, but they are not in themselves elements of a normative importance. They do not have a normative effect for international law. They have a factual effect. And this is the most significant formulation of the theory or the idea that international law is independent from municipal law. And in this respect, it is to be understood then that international law is a system that is wholly independent from other systems of law, particularly the internal systems of states. And this serves to grant legal certainty to states, because it means that the international obligations of a state cannot be modified through the enactment of internal provisions that are wholly within the sovereignty and within the consent of a state. In other words, a state cannot renounce its international obligations by enacting contrary law within its own systems. Now, this closes the subject of whether international law is independent. And as I mentioned, it can be considered to be independent in itself. Of course, you may find academic writings that say that it is superior or it has supremacy over domestic law. And this will be a question that has to be answered from the lens of domestic law itself. Some domestic systems will say that international law supersedes domestic law. Others may say that constitutional law supersedes international law. But from the lens of international law, domestic legal systems are not normatively relevant. The third aspect that can be analyzed when evaluating the nature of international law is its structure. And so for all domestic systems, I would dare to say that all domestic systems have a similar structure in the sense that they are vertical systems. They are systems that have a vertical structure of power. And so we have individuals and corporations and other private entities that have an inferior hierarchical place within the system. And then we have the state that has the power to regulate, the state that has the power to apply the law, and the state that has the power to enforce the law. That is to say, the state that has executive, judicial, and legislative power over private entities. And so the way in which these different jurisdictions, so to say, or these sovereign powers are exercised may vary from system to system, but the same structure will be found in most domestic systems. But when you scrutinize international law from this lens, things can get a little confusing because international law doesn't have a vertical structure. International law has a horizontal structure in the sense that all states are recognized to be equal and no state is allowed to utilize force to subjugate another state to its will. This is a well-established rule of international law. We can find the prohibition of the use of force in the UN Charter itself. This is a subject that will be addressed in a subsequent session, which will also be taught by myself. It will be about the collective security system of the United Nations and the peaceful settlement of disputes. But suffice it to say in this point that as the court said, the ICJ said, in the jurisdictional immunities of the state case in 2012, the principle of sovereign equality is, quote, one of the fundamental principles of the international legal order, and it is recognized in Article 2, Paragraph 1 of the Charter of the United Nations. And it is in itself a productive principle in the sense that this principle is the source of further obligations. And one of the most significant ones that can be mentioned is the principle of state immunity. A state cannot exercise civil or criminal jurisdiction over the legal person of another state unless the second state has already granted consent or has in any other way waived that immunity. Or as the Latin says on screen, between equals, there is no power. There is no power of subjugation or imperium. There is no sovereignty of one state over another. And this being the structure, you will find that although there are international institutions that exercise judicial, executive, or legislative power, for example, the United Nations General Assembly has some extent of legislative power in the sense that by harnessing the practice of states and their opinio juris, the General Assembly can be a significant actor in the development of customary international law. Or the General Assembly can also itself, or through subsidiary bodies, act in the adoption or enactment of international instruments like internationally binding treaties. But the UNGA doesn't have a legislative power in the same way as a Congress or a parliament may have in an internal system. In the same way, we have international institutions that have judicial power. The ICJ is the best example. It is the principal judicial body of the UN, according to the Charter. We also have criminal courts, like the ICC, or the International Criminal Tribunals of Rwanda and Yugoslavia. However, these international bodies that have judicial functions do not have automatic or binding jurisdiction over states and international organizations. As we will be explaining further later, the system of jurisdiction in international law is based on the principle of consent, and thus a state can only be bound to the jurisdiction of an international institution, like an international court, if that state has conferred consent onto that institution. And of course, we also do not have an executive that has the power to impose obligations on other states, with the exception, of course, of the collegiate body that is the United Nations Security Council. According to Article 25 of the UN Charter, the decisions of the Security Council are binding on all UN members. Yet the Security Council has a very limited mandate. It is not tasked with the application or the enforcement of international law in general. It is only tasked with the maintenance of international peace and security. And so they only can exercise this binding force or this binding power when they are faced with a threat to the peace, a breach of the peace, or an act of aggression. And you can see this in Article 41 of the UN Charter. And so in the absence of all of these kinds of institutions, international law raises itself as a horizontal system. And this means that no state has in itself the power to subjugate other states, other than by the exercise of international law. And so this is where subjects like countermeasures, sanctions, and self-defense come into play. Because since no state has superiority over other states, it means that the power of enforcement is in the hands of every state. Every state has the power of enforcement of its own obligations and within the limits provided by international law. And so, for example, a state that has or that considers that an obligation that was owed to it was violated has the right under customary international law to suspend obligations that are owed to the violating state as a countermeasure. Or, for example, a state that has been the victim of an armed attack has the inherent right under the Charter to exercise the right to self-defense. That is to say, to use force in order to defend itself. And so this is something that will be addressed when we delve with the multilateralization of international law. But suffice it to say for now that by virtue of this sovereign equality, one of the most important consequences is that national jurisdiction, national sovereignty, and the domaine réservé of states is protected. That is to say, international law recognizes that there are certain areas of interest that are only within the purview of states, within their own jurisdiction, and that no other state can exercise any sort of influence, or rather coercive influence over those matters. And in fact, the exercise of such coercive influence without the authorization of international law would be a violation of the law. It would be a violation of the principle of non-intervention. We see that this notion of the international legal system as a horizontal system is challenged by some concepts. Among them is the recognition of the rights of individuals, the inherent rights of individuals, which may in some instances provide exceptions to the principle of domestic jurisdiction, or the recognition that in some instances, states do have the power to exercise jurisdiction outside of their territory. And so these are national purview, this national exclusive jurisdiction can be challenged in some circumstances. Now, perhaps the most important aspect of international law, and this is an aspect that you will find in as one of the main subjects of study in most public international law books, is the concept that international law is a system that is based on consent. And this is something that is not easy to challenge when we look at the sources of international obligation or the sources of international law. And for this purpose, I will start by listing the different sources that are enumerated in Article 38(1) of the Statute of the International Court of Justice. These are, I want to clarify, this is not an authoritative list of sources. Rather, it is the list of sources that the court is tasked with applying when solving a dispute. But they are, in general, in the literature and in international jurisprudence, recognized as the starting point of the enumeration of sources. And according to Article 38(1) of the statute, the sources of international law for the ICJ are international conventions or treaties, as is the standard term under the VCLT, custom or customary international law, which is defined as the general and constant practice of states that is performed out of the belief that such a practice is mandated by a rule of law. That is to say, state practice and opinio juris. The third source is general principles of law. The Article 38(1)(c) of the statute says the general principles of law recognized by civilized nations. In the reinterpretation of this phrase by the ILC, it is the general principles of law recognized by the international community as a whole, in essence. And some of these principles that you may find will be, for example, the principle that treaties must be performed, the principle of pacta sunt servanda, for example. Or one of the principles that I already mentioned, the principle that par imparem non habet imperium, that equals cannot exercise power over one another. We also have other subsidiary means for determining the law or subsidiary sources, which I have mentioned are literature or doctrine and international jurisprudence. These are not subjects of law in themselves. That is to say, they are not formal sources of law. Rather, they are material sources that aid the international tribunal in determining the content of the law. We also know that there are some sources that are not mentioned by the ICJ statute. For example, unilateral declarations of obligation or of intention, which may, in specific instances, create obligations for states. Or, for example, resolutions handed down by international bodies, such as the resolutions of the UN Security Council. These may be interpreted as their own source or as the manifestation of treaty law in individual cases. But the point is that these sources are not mentioned in the ICJ statute. And so what you will find as the common element in all of these sources, in one way or another, is that consent plays a very important role. A state cannot be forced to perform a treaty if that state has not expressed its consent to be bound by the treaty. And so, for example, a state that has not ratified a convention cannot be forced to perform it. Customary international law is also based in let's say, a positive idea of consent, in the sense that by partaking in the general and constant practice of states, and by believing that this practice is mandated by law, a state is giving consent to the customary obligation. And an example of this consent-based understanding of custom is the notion of persistent objector. A persistent objector is a state that has, as the name indicates, persistently objected to a rule of customary international law while it was in its stages of formation. And so by withdrawing consent to this obligation, some say that the notion of persistent objector allows customary international law not to apply to certain states. For example, some say that nuclear weapon states are persistent objectors of the so-called general ban on nuclear weapons under customary international law. Of course, general principles of law can either be created within the system itself or by transposition from national systems. And the other sources are also rooted in consent, in the sense that the states are bound by UN Security Council resolutions because states have signed the UN Charter, or states are bound by unilateral declarations because they themselves have issued them. And we also note, as I mentioned previously, the jurisdiction is also deeply rooted in the principle of consent. And so, drawing upon the idea that international law is a horizontal system, we see also that international law is a system that is primarily based on the consent of states and international organizations. And when you scrutinize this notion of the law as being based on consent, the primary idea that you will find when looking at it from the lens of domestic law is that the international legal system can be more easily assimilated to systems of contract, to systems of private law, where obligations are based on the consent of the parties. And so it would look like, from its inception, international law has a private law structure. If you want to delve more deeply into this notion that international law has the structure of private law, I would recommend a book recently published by the author Robert Culp that is called International Law as a Body of Private Law or a Body of Public Law. This is a very extensive book, but since it is part of the Hague Academy's pocketbook series, it is rather accessible from the economic perspective. And so this is a concept that is analyzed extensively in that book. So as to not go too deeply into that concept, I will be mentioning some of the evolution throughout the years of this concept of international law as a system based on consent. And what we see is that this individualistic private system of contract that was established between states based on treaty and consent and custom has been challenged in recent years. We see more and more the influence of collective interests, the influence of public law concepts being seeped into the system of international law. You will find this under a varied number of names. You will find concepts like aggravated state responsibility. You will find jus cogens. You will find erga omnes obligations, or you will find exceptions to domestic jurisdiction. This is what I like to call, from an academic perspective, the multilateral public order that is emerging in recent years. And I will explain some of these in this slide. So the first is the idea that is born in the UN Charter that the use of force is subject to a system of collective security, in the sense that the use of force between states is prohibited, except where it is authorized by the Security Council as a multilateral body within the UN, and that any use of force that is not authorized or sanctioned by the UN Security Council needs to be exercised in self-defense, and there is no other exception to that. This is the structure as we find it in the UN Charter. And so any use of force that does not fall either under UNSC authorization or within the rubric of self-defense would be illegal. It will be an act of aggression, and it will trigger the obligations of the Security Council to maintain collective security. And so we see that the notion that the use of force is an instrument of public policy has been abandoned. And now security from a collective perspective has taken hold in the international system. This is a collective interest that is at the very foundation of the modern system of international law. The second significant development in this respect is the idea that there are certain international conventions that are not simply bilateral exchanges of rights and obligations. There are certain conventions that are inspired by public interests, and therefore they are not subject to reciprocal considerations. We see this in, for example, explanations of treaties governing international humanitarian law or international human rights law, which are intended to benefit individuals and not states, and therefore states cannot suspend them based on any notion of reciprocity. And this idea was made positive by the ICJ in its, I believe, 1951 advisory opinion on reservations to the Genocide Convention, where the ICJ recognized that the Genocide Convention is a treaty that is not simply an exchange of rights and obligations between the states that are parties to it. It is rather a multilateral, non-bilateral instrument, a non-synalagmatic or non-reciprocal, instrument of law. And the court mentions that this dual character of consent, but also public interest, is best represented by the Genocide Convention, because its very raison d'etre is the protection of individuals. It is a humanitarian treaty, and therefore it is based on notions of what the court calls moral law or international morality, rather than simply international consent. And so we see that the regime of international treaties starts to evolve to recognize that certain interests are not simply reciprocal. They are multilateral. They are non-reciprocal. And therefore, they are not subject to a simple conception of consent. Then we see, as I mentioned multiple times, the emergence of international human rights law. We see that with the emergence of human rights law, which confers rights on individuals themselves as beneficiaries of international law, the idea that domestic jurisdiction is absolute and that states have a domaine réservé that allow them to regulate matters within their territory as they please has broken apart. This principle is no longer as absolute as it used to be. In fact, the interest nowadays in the protection of individuals has led to the recognition that there are certain concepts that transcend the horizontal consent-based system that international law used to be. And this squares very, very nicely with the development of the concept of jus cogens. This is a concept that I mentioned previously. For those that do not know what jus cogens is a concept within international law that refers to rules of general international law from which no derogation and no exception is permitted. That is to say, they are mandatory, imperative, peremptory norms of international law. A state cannot set aside these rules by contracting a treaty, by concluding it or becoming party to it, or by developing a contrary custom. These principles are absolute and cannot be contradicted by any other rule of international system. And which rules are part of jus cogens? Well, when this concept was introduced in the Vienna Convention on the Law of Treaties in 1969, particularly in Articles 54 and 63, this concept was not very clear. In fact, if you see the decision of the ICJ, even almost 20 years later, in 1986, in the Nicaragua case, the court still hesitant in recognizing this concept. But nowadays, following the work of the International Law Commission on jus cogens, we see that there are certain obligations that are recognized as peremptory. Some of them are the basic principles of international humanitarian law. For example, the protection of civilians. The prohibition of genocide is also considered to be a peremptory norm of general international law. The prohibition of crimes against humanity, the prohibition of apartheid as a crime, the prohibition of war crimes in general is also considered peremptory. And most significantly, the prohibition of the use of aggressive force is considered also to be part of jus cogens. And so all of these obligations are considered to be so important within the system, so much as embodiments of public collective interests, that individual consent cannot stand against them. They cannot be contracted out through a system of private contract like we will see in the law of treaties. And as part of this recognition of jus cogens as a special category of norms, we see the recognition that the violation of these norms, particularly the systemic or the gross violation of these rules, generate a special kind of responsibility. You can see this in Articles 40 and 41 of the International Law Commission's Articles on State Responsibility, or RCWA, where it is stated that the gross or systematic violation of a peremptory norm of international law is met with three basic consequences. The first is a duty of not recognizing the situation created by the violation as lawful. That is to say, a duty of non-recognition. The second is the obligation of cooperation. That is to say, it is the obligation of all other states to cooperate through lawful means to bring the violation of jus cogens to an end. And thirdly, we see an obligation of non-assistance. That is to say, the obligation of states not to render assistance to a state that is violating this norm of jus cogens, and not rendering aid to the maintenance of this illegal situation. What you may notice from these components of aggravated state responsibility is that they embody collective obligations. And the collective nature of these obligations can be more easily analyzed when looking at the ICJ's Namibia advisory opinion, where these are enunciated and which was one of the inspirations for the creation of these articles. And so these different notions of multilateral public order have taken hold in the international system. And perhaps one of the best examples of this is the recognition of erga omnes obligations, or erga omnes partes obligations. And so the question for a very long time in respect of the question of erga omnes was whether or not they could be recognized under international law. So what is an erga omnes obligation, or an erga omnes right, depending on how you analyze it? An erga omnes or erga omnes partes obligation is an obligation that is not owed to a particular state, or rather is owed to a collection or a group of states. When you're dealing with erga omnes obligations, you are dealing with an obligation that is owed to the community of states as a whole. One example of this could be the prohibition of genocide. In fact, the majority, if not every single one of the rules of jus cogens are simultaneously recognized as erga omnes obligations. And an erga omnes partes obligation would be an obligation that is owed not to the international community as a whole, but to the totality of the membership of a treaty, the totality of the participation of a treaty. And so an erga omnes partes obligation would be an obligation that is owed to all state parties to the treaty. And so the most relevant aspect of this concept of erga omnes or erga omnes partes obligations is that it creates a right under international law to bring claims, even though there is no injury accruing to the state that brings the claim. So as you may know, there is a rule, a general rule that is based on this bilateral consent-based system, that a state can only bring a claim if it itself has been injured, either directly through its own rights, or indirectly through the rights of its nationals, through the process of diplomatic protection. And this was the idea that prevailed in international law for a very long time. And so you can see in the 60s, in the Southwest Africa cases by the ICJ, that the ICJ said that there was no concept under international law of an actio popularis, or a public action, or a public interest action to bring claims when there is no injury. And so this was the reason that was raised by the court by a very thin margin within the judges to reject the claim brought by Ethiopia and Liberia against South Africa. And this judgment was very much criticized for a long time. In fact, a few years later, in the Barcelona traction case, the court backtracked a little bit and recognized in a famous dictum that there are certain obligations that are of an erga omnes character. And it recognized, for example, the prohibition of genocide and the prohibition of slavery as such erga omnes obligations. That is to say, obligations that are very grave. They're very grave violations of human rights and the fundamental rights of individuals. But then we see in subsequent cases, particularly the 2012 Belgium v. Senegal case concerning the obligation to prosecute or extradite, and the ongoing procedure between the Gambia and Myanmar regarding the application of the Genocide Convention, that the court has been more amenable to the recognition of this concept of erga omnes partes. And it recognizes that obligations under the Convention Against Torture and the Convention Against Genocide are of an erga omnes partes character. And so states that are not injured can bring claims on behalf of persons that are not their nationals based on the violation of such an important rule that is opposable to every state party to the convention. Some other examples of multilateral concern would be the increasing number of judicial interventions before the ICJ. We see that, for example, in the case concerning allegations of genocide filed by Ukraine against Russia following the act of aggression that started on the 24th of February of 2022. Around 33 states filed declarations of intervention under Article 63 of the ICJ statute. And these are states that are not injured by the invasion or the so-called allegations of genocide leveled by Russia, but they are states that are concerned by the underlying claim brought by Ukraine. They want to express their support for Ukraine, and therefore they have asked to be participants within the court. So this is an example of multilateral concern. And we see that recently, I believe it was like a week ago, that 3 or 4 states asked the court for intervention in the Gambia versus Myanmar case concerning the application of the Convention Against Genocide. And so we see this increasing evolution of the international system where collective public interests are starting to take hold. And the system, although still based on consent, is starting to give way to non-consensual concepts, such as the concept that certain rules, jus cogens rules, cannot be contradicted through consent. And the final subject that I want to address is the concept of international law as a fragmented system. That is to say, the system of international law as a system that suffers from fragmentation. Fragmentation is not a concept that you will find easily in introductory books on public international law. This is rather a complicated notion, and it is not my purpose to address it in its full extent in this presentation. But if you are interested in looking more deeply into this question, which is a fascinating question, you can look at the 2006 report by Special Rapporteur Martti Koskiniemi from the ILC regarding fragmentation in international law. This is a very detailed report on this phenomenon. And to summarize what this phenomenon entails is the concept that international regimes based on treaty law, based on treaties, are starting to branch off and create what we can call pockets or microcosms of international law. Take, for example, an international treaty, for example, an international human rights treaty, the Convention Against Torture, the Convention Against Apartheid, or even a simpler example like the International Covenant on Economic, Social, and Cultural Rights of 1966. These conventions regulate rights for individuals that are aimed at a particular focus. And so these human rights bodies, these human rights treaties, create in themselves treaty bodies that are in charge of applying the law that is regulated in those conventions. And so through the practice of states and through the development of policy through these treaty-based human rights bodies, the law of the convention branches off. It becomes fuller, it becomes more detailed. And by becoming more detailed, more specialized, this body of law starts to separate from the general body of law. And so these different treaty-based regimes start to branch off from the general law to the point that they become so different that they may even become mutually incompatible. This is a very concerning development in international law, because it means that the concept of general international law may start to disappear. And so in an effort to prevent this notion of conventional regimes or self-contained international law from breaking apart the system as it stands today, scholars and tribunals have developed concepts such as the notion of systemic integration, which I will be addressing very briefly just now. But before I do that, it is very important to notice as well that one aspect that that makes this concept much more complicated is the notion of the autonomy of sources. The autonomy of sources is the idea that the different sources of international law are autonomous between themselves. And the best way to explain it is referencing the ICJ's judgment in the Nicaragua case, 1986, where the court said that, quote, even if a treaty norm and a customary norm relevant to the present dispute were to have exactly the same content, this would not be a reason for the court to take the view that the operation of the treaty process must necessarily deprive the customary norm of its separate applicability. In other words, treaty and custom exist independently, and the change in treaty law does not necessarily or does not automatically change custom. And also, the change of custom doesn't automatically or necessarily change treaty law. So when looking at these conventional regimes that are branching off, the creation of self-contained international law like WTO law, human rights law, or even international criminal law starting to show the symptoms of this, and the principle of autonomy of sources, the question of fragmentation becomes very complicated. It becomes very difficult to solve. And so in the 2006 report on fragmentation, a special rapporteur, Martti Koskiniemi, proposes different methods of delving with this. Some of these methods have been recognized by international institutions, particularly international tribunals. The first mechanism to tackle fragmentation is to avert or prevent normative conflict altogether. That is to say, to interpret rules of international law by reference to other rules that may otherwise be in separate or self-contained regimes. This is the concept of systemic integration. And you can find it in Article 31.3c of the Vienna Convention on the Law of Treaties. This provision says that in interpreting a treaty, the interpreter has to take into account any relevant rule of international law that is applicable in the relations between the parties. And so, for example, when applying the GATT, the 1994 GATT, in its decision in the case of United States shrimp, the appellate body of the World Trade Organization recognized that the concept of endangered species is not found within WTO law. And to find what it means to be endangered, the appellate body referred to the CITES Convention. That is to say that the treaty governing trade in endangered species. And so the effort here is trying to prevent normative conflict by interpreting rules of international law by reference to other rules. And when normative conflict is not possible to be averted, the solution is to have recourse to the principles of law that you will study when analyzing conflict of laws in different territories. So you have lex superior, lex posterior, and lex specialis. As you may know, the principle of lex superior says that the law or the norm of the higher status or higher hierarchy must supersede the inferior norm. The principle of lex superior says that the subsequent law must supersede the prior law. And the principle of lex specialis says that the more specific law must supersede the general law. In international law, it is not very clear which of these principles must be applied first. In fact, there are very, very difficult issues that arise out of them. For example, as I mentioned before, international law is horizontal. And because international law is horizontal, there are very few norms that are truly recognized as superior. Examples of this could be Jus Cogens norms or the UN Charter, which according to Article 103 of that treaty, supersedes other treaty obligations in case of conflict. We can see evidence of the principle of lex posterior in the Vienna Convention on the Law of Treaties, where it recognizes that the conclusion of subsequent treaties can be a ground for termination of a prior treaty. This is in, I believe it's Article 60 or 61 of the convention. I do not remember at this moment. And the principle of lex specialis can be found everywhere. And one example of this is Article, I believe, 55 of the ILC Articles on State Responsibility, where it says that any special rules regarding responsibility supersede the general rules found in the articles. Whether or not you apply all of these principles together, which of them have a preeminence, is not an easy question to answer. I would recommend that you look more deeply into the 2006 ILC report on fragmentation, which will give you a lot of the answers to this complicated issue. And so, in essence, international law is a system that is fragmenting. There are efforts at the international level to mitigate or even prevent this from happening. And so with this and having reached the 1 hour mark, I will pause here. And I want to ask if there are any questions regarding any of the subjects that I have explained or any related subject. I see that there are no questions in the chat. In case you have any question, you can raise your hand. Excellent. So I see that there are no questions. With this, therefore, I will close the first session of this Latin American Jessup School. I very much thank everyone for staying over from the Q&A into the public international law session. If you have any questions, you can send it to the organizers of the Latin American School. And I hope to see you tomorrow in the session regarding diplomatic and consular law. Good night.
Thank you. Good night.
Thank you.
Good night.
Good night.
Thank you. Good evening.
See you.
Thank you, sir. Good night.